Good evening and welcome back to AJ 102. And tonight we are going to be discussing Chapter 13, the U.S. Courts. This is going to be quite a long chapter, but I am going to try to squeeze it in. So, again, this would really be one of those chapters that I need you to kind of dig into your textbook and read a lot of the information in between some of the topics that I'm going over. Also, take a moment and go through the definitions on page 512. It would be very beneficial to you, along with looking at some of the do you know questions and seeing how you can do with some of those, because those are a great way to kind of help you study. So this chapter is going to begin with an overview of the court systems in the United States. We're going to look at state court systems, federal court systems, juvenile court system, and the Supreme Court, and a couple other systems as well. We'll take a few minutes and talk about the adversary system and its key players like the defendant, the prosecutor, defense attorneys, the judge. So we'll learn all the different positions, if you will, in the court system. We'll look at some descriptions of the critical stages in the criminal justice system, keeping in mind that not all cases result in a court trial. There are alternatives to trial that are going to be discussed, including things like diversion and plea bargaining. And then at the end, we'll conclude with a basic discussion, if you will, on the police officer's role in the courts and then courtroom testimony. So by way of introduction, police officers really need to become familiar with criminal jurisprudence, meaning that they understand the science or philosophy of the law, because it really is important that you know what you're talking about. Prosecutors are the gatekeepers to the judicial system, just as police officers are the gatekeepers of the criminal justice system. So officers should recognize and understand the various levels of courts, and then also prisoners released on parole and defendants sentenced to be released on probation can sometimes be somewhat of a concern because they're going to be coming back into society. So this introduction really is kind of framed this way. Police officers really must become familiar with our courts as well as each step of that criminal justice process, because they may find themselves playing important roles in this component of the system. We talked about it. They should be familiar with criminal jurisprudence. And what does jurisprudence mean? Well, it's the science or philosophy of law in a given area or department of law. Just as law enforcement officers are the gatekeepers for the criminal justice system, using their discretion about who to arrest, prosecutors, on the other hand, are the gatekeepers to the judicial system, using their discretion to determine who to charge and who to bring to trial. So, and sometimes, I kind of hate to say it, but friction may occur between the officers and the prosecutors when they disagree on whether or not a case is strong enough to bring to trial. So, that's one reason that the officer needs to be familiar with the system. But additionally, if a case does go to trial, the officers are frequently called upon to testify. Therefore, they should be familiar with not just the system, but the courtroom itself, as well as how it operates and their role as a government witness. And then finally, keeping in mind that prisoners released on parole and defendants sentenced to be released on probation are of a concern, and the reason is that the reality is these parolees and probationers are going to be living within some local department's jurisdiction where officers are going to be charged with keeping the peace. And if you look at the numbers, and these numbers are a little bit old, and they're more, but these are the numbers back in 2011, the Bureau of Justice Statistics reports that at year end in 2011, there were approximately 4.8 million adults under community supervision. 82% were probations. A sentence of probation, may anger and frustrate law enforcement officers who work the case and see such sentences as contributing to the revolving door of the criminal justice system, but that's not necessarily how it is. There is a place for plea bargaining, and there is a place for probation. So the court system as an overview, here's kind of a schematic, if you will, of the court system. U.S. courts operate within a highly structured framework that may vary greatly from state to state, so they could be different. Many dualities exist within this framework. One such duality is their jurisdiction, which refers to a geographic area and to a court's authority to try or adjudicate a case or to hear an appeal. The duality being that of the original court versus the appellate jurisdiction. So by way of definition, a court with original jurisdiction has the authority to try cases, where a court with appellate jurisdiction has the authority to hear an appeal to set aside a conviction without holding a trial. Does that make sense? In some cases, a court has both types of jurisdictions. For example, the U.S. Supreme Court would have both of those. Another word that you'll hear is adjudication. That's the process of judicially deciding a legal case. A court with authority to adjudicate a case is often called the trial court. That's how we usually hear it. And because such courts are often first to record the proceedings, sometimes they are also referred to as the court of record. So looking at the two different structures or frameworks here, you have federal on left and state on right. For the state court system, each state's constitution and statutory law establishes its court's structure. Consequently, great variety exists in the type of courts established, the names by which they are known, and the number of levels in that particular hierarchy. So here's just kind of a basic structure where you can look at the state court. You can see on the bottom trial courts of limited jurisdiction, municipal, county, and state jurisdiction. Trial court, next up, trial courts of general jurisdiction, superior courts, then intermediate courts of appeal, then appellate court of last resort, usually called the Supreme Court, and then you can go one step higher, going over to the left and to the other framework, the federal court system, the Supreme Court of the United States. So most cases, however, originate in a municipal or county court. And it is in such courts that most law enforcement officers could be called to testify. Although municipalities and counties are self-governed and have their own courts, they need to comply with state and federal laws. In some states, cases may be appealed to an intermediate appellate court. In every state, the state Supreme Court is the court of last resort at that particular level. Now, juvenile courts, a little bit different. For more than a century, the United States has had a court system separate from the adult criminal court to deal with juveniles. In 1899, Illinois passed the Juvenile Court Act, creating the first juvenile court in Cook County and beginning an era of social jurisprudence. The court's primary purpose was to help to rehabilitate wayward children so that they would become productive community members. This act, however, also gave expanded jurisdiction to the juvenile court in handling those youths who broke the law and in regulating the treatment and control of dependent, neglected, and delinquent children. So one issue to think about here is the Juvenile Court Act equated poor and abused children with delinquent and criminal children and provided that they be treated in essentially the same way, establishing kind of a one-pot approach, if you will. Most juvenile court systems today kind of have the same dual charge. The Chicago legislation grew out of the efforts of civic-minded citizens who saw the inhumane treatment of children confined in police stations and jails. The legislation included many characteristics of our current juvenile courts, including a separate court for juveniles, separate and confidential records, informational proceedings, and the possibility of probation. The act was also grounded in the English common law doctrine called parens patriae, and it's P-A-T-R-I-A. It's kind of hard to say. You can say it however you want. Meaning that the state was responsible for the general protection of all people within its jurisdiction who could not protect themselves, and that included children. So, parens patriae, the right of the government to take care of minors and others who cannot legally take care of themselves. And historically, juvenile courts have been informal, private, non-adversarial systems that stress rehabilitation rather than punishment of youths. And one more kind of quick note, and then we'll start to move on. Juvenile courts vary from state to state, but most of them begin with some sort of intake process, usually starting with a petition. And a petition is basically a document alleging a juvenile is delinquent, status offender, or dependent, and asking the court to assume jurisdiction of the child. So it is the formal process for bringing a matter before a juvenile court. And hopefully that makes sense to you. So as we start to move on now, we're going to go to the left. We talked about state, we talked about juvenile, and then we're going to hit on the federal court system really quick. So just as with state courts, a hierarchy exists among the federal courts. The federal court system has basically 4 tiers. Magistrate courts, also called non-Article 3 courts, district courts, appellate courts, and then the U.S. Supreme Court. A state may be divided into federal districts, and districts never cross state lines. There are 94 district courts across the United States and its territories, 89 districts in the 50 states, as well as a separate district court in the District of Columbia, and 4 territorial district courts in Guam, the Northern Mariana Islands, Puerto Rico, and the Virgin Islands. The appellate courts are organized into circuits, with each circuit encompassing several states. Currently, there are 11 circuits in the continental United States, plus a DC circuit. 2 additional circuits exist: the Court of Appeals for Federal Circuit and the Court of Appeals for the Armed Forces. So, what's the highest court in the land? At the very end of the day, how high can we actually go? Well, the answer would be the U.S. Supreme Court. The United States Supreme Court is the high court of last resort in this country and is presided over by 9 justices appointed by the President of the United States, subject to Senate confirmation. The President also appoints a Chief Justice who assigns the cases to the other justices. Now, most of these justices have a background in law. Most have been lawyers from, upper class law firms and things like that. Now, one myth is that once a case gets elevated to the level of the Supreme Court, there is a good chance the court will hear it. Well, that's not really true. Very, very few cases that are petitioned to the Supreme Court are actually heard. Any case that does not have at least one justice expressing an interest in it is basically denied, which accounts for the disposition of more than 70% of the cases submitted. Now, keep in mind that this court doesn't retry these cases. The Supreme Court typically looks at constitutional issues. And typically that's how that court operates. So the mere fact that something lower level at a trial may have been a mistake, or something may not get it to the Supreme Court, but the Supreme Court will look at the constitutionality of all of those issues. So in order to get your case to the Supreme Court, you have to submit what they call a writ of certiorari. And the Constitution established tenure for life on good behavior. Therefore, the only way to remove a justice is through impeachment. So we're talking now about basically two different things. I didn't mean to confuse you. So these justices, just to kind of finish that off, they are there forever, okay, until they either pass away, quit, or they are impeached. So there can be voluntary retirement can be obtained, but the only way to remove a justice is through impeachment. Now, when the when the Supreme Court decides to hear a case, it grants that writ of certiorari that I talked about, which is a request for a transcript of the proceedings of the case for review. So that's how that goes. When the Supreme Court rules on a case, that ruling then becomes what we call precedent, commonly referred to as a landmark decision, which must be honored by all the lower courts. The use of precedent in the legal system gives the Supreme Court power to influence and mold the everyday operating procedures of police, basically. So we've ran through all of these courts here, but there are also some other ones that are out there. And I'm not going to take a lot of time on these, but we'll kind of just get the tip of the iceberg here. So there are some specialized courts out there for specific cases. Specialized courts have developed to address specific criminal justice cases. And it is hoped that these alternatives to the traditional courtroom will just kind of dispense more equitable justice as applied to a particular issue. So among the specialized courts are tribal courts, community courts, problem-solving courts like drug courts, DUI or DWI courts, domestic violence courts, mental health courts, homeless courts, reentry courts, and juvenile courts. All of these are specialized. The tribal court system includes trial and appellate courts, as well as specialized civil, criminal, family, healing, wellness, juvenile, and drug courts. These courts hear cases pertaining to Native American law that affect both Native Americans and non-Native Americans living or operating a business within the jurisdiction of a Native American government. Community courts are neighborhood-based and seek to solve local problems. They bring together local resources, create problem-solving partnerships with community groups, government agencies, social service providers. Similar to other collaborative justice courts, community courts aim to improve efficiency in judicial proceedings, match up sanctions and services to offenders, and build bridges between public and private agencies that serve offenders. So these community courts focus on quality of life crimes and cleaning up neighborhoods. Problem-solving courts seek to achieve tangible outcomes for victims, offenders, and society. These includes reductions in recidivism, like reoffending, reduced stays in foster care for children, increased sobriety for addicts, reentry courts for prior offenders, and healthier communities. So these problem-solving courts use a collaborative approach, relying both on government and nonprofit partners. They promote reform outside of the courtroom as well as inside the courtroom. Drug courts commonly are community-based courts designed to reflect community concern and priorities, access community resources, and seek community participation and support. And they do this by providing drug treatment to offenders as soon as they enter the court system instead of waiting until they've passed into the correctional component of the criminal justice system. Drug courts have taken quite a different path from traditional court processes, and again, generally involve things like it's a team effort, use of mandatory drug testing, continuous supervision, immediate response to non-compliance, and incentives to encourage compliance. Domestic violence courts, according to the Center for Court Innovation, an important part of domestic violence court involves putting victims in touch immediately with social services. Victim safety is the cornerstone of domestic violence courts. Mental health courts, so there are just a vast array of different courts that are out there. The main goal of such courts is to interrupt that revolving door for those with mental health problems from street to court to cell and back again without ever receiving some type of service. So you can see the importance of the mental health court. A team approach, screening and assessment, diversion, early interventions, emphasis on problem solving, strong focus on supervision, understanding by the mentally ill their participation in this court is voluntary, a more personal interaction. So there's those. Homeless courts, designed to help homeless defendants resolve outstanding misdemeanor criminal cases. In the homeless court program, the traditional court sanctions of fines, public works, service, and custody are replaced with alternative sentencing. Because if you have a guy or a gal that's homeless and they're living on the street and you give them a ticket for like blocking the sidewalk, living on the street or whatever, how are they going to deal with that? You're just going to keep stacking things on top of them. So that's the rationale behind that. Reentry courts, a relatively recent specialized court, is reentry, of which there are presently at least 24 throughout the country. Reentry courts serve parolees before they're released from incarceration by working with correctional staff to develop detailed profiles of participating inmates that include information about medical status, addiction, criminal involvement, living arrangements, vocational skills, family composition, all of these things to really help customize a treatment and supervision plan to make sure that, or to help these people possibly succeed. There are teen and youth courts, there are juvenile drug courts and gun courts, there's waiver to adult courts, and I'm not going to go into all of these, but again, these are a lot of different court systems out there that we may not know about. So moving on, our court system, our criminal justice system is based on this term adversary system, basically meaning the accuser versus the accused. Our adversary criminal justice system requires the accuser to prove beyond a reasonable doubt to a judge or a jury that the accused, in fact, is guilty of a specific crime. And in order to do that, we're going to look at some things called presumption of innocence, reasonable doubt, preponderance of evidence, impartial judge and jury, and varying degrees of certainty. So, presumption of innocence means that the accused is assumed innocent until proof to the contrary is clearly established. Innocent until proven guilty. Excuse me. On the side of the accused are the defendant and the defense attorney. On the side of the accuser is the citizen or the victim, the prosecutor, and the police officer. Now, the prosecution, bear the burden of proof. An impartial judge or jury hears both sides of the controversy and then reaches a decision whether the accuser has proven the accused guilty beyond a reasonable doubt. That state of a case in which, after comparing and considering all of the evidence, the jurors cannot say they feel an abiding conviction of the truth of the charge. Jurors are morally uncertain as to the truth of the charges. So let me kind of go back and clear that up. Reasonable doubt. that state of a case in which, after comparing and considering all of the evidence, the jurors cannot say they feel an abiding conviction of the truth of the charge, moral uncertainty of the truth of the charges. Okay, so that's reasonable doubt. So meaning that, hey, there's some doubt that after weighing all the evidence, there's some uncertainty, some moral uncertainty. Now, preponderance of the evidence is, on the other hand, a greater weight of evidence. So reasonable doubt is more stringent evidentiary standard than required in a civil trial, where a mere preponderance of the evidence is the standard. So the preponderance of the evidence standard simply means that it is more likely than not, based on the bulk of the evidence, that the plaintiff's version of the case holds up. So, these are just a couple of terms that you'll probably need to know. And then impartial judge or jurying, and then varying degrees of certainty we'll kind of get into in just a little bit. Now, if you look at your textbook on page 524 under table 13.1, there is a kind of a table that is the evidentiary standards of proofs or degrees of certainty. So it talks about absolute certainty, beyond a reasonable doubt, clear and convincing evidence, preponderance of evidence, probable cause, sufficient evidence, reasonable suspicion, less than probable cause, and it defines all of those for you. So you can take a moment and you can kind of look at those while we move on now to key players in the judicial process. So key players in the judicial process include the defendant, prosecutor, defense attorney, judge, and jury. Well, the defendant, everybody pretty much knows who that one is. Everyone, including a person suspected of committing a crime, has certain rights that must be protected at all stages of the criminal justice process. Defendants have all the rights set forth in the Bill of Rights. Now, they may waive these rights, but if they do, that waiver should be in writing, because proof of the waiver is up to the police officer or the prosecution to basically define. So again, keep in mind that just because you're a defendant doesn't mean you're without any rights. This is all part of the process. Now, the Fifth Amendment guarantees due process, notice of a hearing, full information regarding the charges made, the opportunity to present evidence before an impartial judge and jury, and the right to refrain from self-incrimination, so testifying against yourself. The Sixth Amendment establishes the requirements for criminal trials, including the right to a speedy public trial by an impartial jury and the right to have a lawyer. The Eighth Amendment forbids excessive bail and implies the right to such bail in most instances. So, the Bill of Rights, the first 10 amendments, you should know those. And even though we're kind of stuck on talking about the defendant, you should know the first 10 amendments along with the 14th Amendment. And I would really suggest that you kind of go through those, and you can Google them and it'll give you the information. But I think I actually put a PowerPoint slide in either the information area or the content area that talks about the first 10 amendments. So the next player in the game is the prosecutor. A prosecutor is an official elected to exercise leadership in representing the government and therefore the people in the criminal justice system. Prosecutors may be city, county, state, commonwealth, or district attorneys. They are usually elected to a 2 or 4 year term at the state level, and at the federal level, they are usually appointed by the president. So that's just kind of a really quick down and dirty overview. Prosecutors have the dual function of, again, leading the law enforcement community while protecting the rights of the accused. So they have to do both. Okay, the defense attorney Everybody pretty much knows who that is. The defense attorney represent the accused in court. Lawyers who represent the accused have the same duties and obligations, whether privately retained, serving as legal aid in the system, or appointed by the court. And the one, in most criminal cases, are assigned to public defenders, as they call them. Very few to private lawyers who handle such cases. A public defender is a court-appointed lawyer hired by the state or county government to represent people who cannot afford to hire an attorney. Many lawyers donate time to represent those that can't afford it, and that's called basically pro bono work, meaning work done for free, where they volunteer their time. Judges, although most people think of trial judges when they hear the word judge, many different kinds of judges exist. If a person comes to trial, he or she will already have encountered certain levels of the court system and judges acting within that system. The various types of judges and the function they serve depend upon the court to which they are appointed. Judges have many important functions throughout the entire process and can exercise great discretion by accepting or rejecting pleas, deciding in preliminary hearings if evidence is sufficient to justify prosecution, or dismissing a case, determining whether to grant bail, and if so, how much, deciding whether to grant delays, presiding over the trial, giving jury instructions, imposing the sentence if a defendant is found guilty. Judicial discretion, however, can also lead to a significant amount of sentencing disparity. And, that's really one of the real important things where, these judges need to make sure that they are all, kind of operating on the same page. And then the jury, well, that pretty much speaks for itself. The jury will be the ones that will be deciding the outcome of a particular case, if in fact it is a jury trial. So when you look at now steps in the criminal justice process, on page 529 of your textbook, there is a kind of a schematic, if you will, that talks about or shows the entire process from complaint made by police officer or citizen all the way through an arrest, booking, misdemeanor case, a felony case, all the way through sentencing. So, keep in mind that the way the system is supposed to work and the way that it actually does isn't always the same. So, and sometimes some of these steps are kind of moved around a little bit. So, but there are several steps, critical steps or stages in the criminal justice process. The criminal justice process consists of the steps that occur between and include the filing of a complaint through the acquittal or sentencing of an offender. An acquittal is a formal certification by the court stating that the accused is found not guilty of the crime he or she has been charged with. So, wanted to make sure that we got that through. But look on that page 529 and go through that whole process. Now, usually the criminal justice process begins when a police officer or citizen approaches the prosecutor to obtain a complaint. A complaint is a legal document drawn up by a prosecutor that specifies an alleged crime and the supporting facts providing probable cause. So a formal complaint, also called the charge, is the legal document drawn up by a prosecutor. Okay, that again specifies the alleged crime and the supporting facts that providing probable cause to make the arrest and what have you. So those are just a couple of terminology things that we're going to go through. So the stages in the criminal justice process. So we have the players, the stages basically as we go through. It would be bail and writ of habeas corpus. One of the Usually one right of the accused is the right to be released from custody in keeping with the legal premise that a person is innocent until proven guilty. After the formal booking process is completed, the suspect is usually entitled to be released on bail or released on his own or her own personal recognizance, meaning that if a crime is a misdemeanor, or released on a writ of habeas corpus if the crime is a felony. But so you can be released on bail, or you can be released on your own recognizance. If the judge will decide how much bail is reasonable as a deposit, if you will, to bring the defendant back into court if released. Some defendants use a person or a company that pays the bail for the defendant for an additional fee, like a bail bond. Okay, so that's another one. So that's the bail and writ of habeas corpus. The preliminary hearing, in a preliminary hearing, the judge determines whether probable cause exists for believing that an offense has been committed and that the accused committed it. Most statutes and rules of criminal procedure require a preliminary hearing to be held within what they call a reasonable time. The preliminary hearing seeks to establish probable cause to prevent people from being indiscriminately brought to trial. So the judge in a preliminary hearing is not bound by the rules of evidence that are usually set forth in a trial. The prosecutor really needs only to establish probable cause, not proof beyond a reasonable doubt that the crime was committed. In reality, that preliminary hearing is often referred to as kind of a mini trial, where the defense obtains as much information as possible in order to possibly strengthen his case. And both the prosecution and the defense often use this stage of the criminal justice process for kind of, tactical intel gathering. So that's the preliminary hearing. There's also a phrase in there called the discovery process. That's a system that requires that all pertinent facts be made available to the prosecutor and the defense attorney before the trial begins. Next on the list is the grand jury. The U.S. Constitution requires an indictment by a federal grand jury before trial for most crimes against federal law. Okay, the consideration of a felony charge by a grand jury is not a trial. Okay, only the prosecution's evidence is usually presented and considered. So contrary to the popular portrayal of grand juries on television and in the movies, suspected offenders are usually not heard, nor are there lawyers present to offer evidence on their behalf. Basically, it's the prosecutor that is presenting information for the grand jury to decide whether or not they're going to indict or not. Coroner's jury. Coroners investigate violent deaths where suspicion of foul play exists. By law, coroners may conduct autopsies to determine the cause of death, and they may conduct what they call an inquest. The coroner's jury usually consists of 6 members. In some states, the coroner's jury system has been abandoned, and its functions are performed by basically a professional medical examiner. But at least you know what the coroner's jury is. An arraignment: when defendants are charged with a felony, they must personally appear at what they call an arraignment. As in the preliminary hearing, they are entitled to an attorney. The procedures of the arraignment vary by state, but generally, defendants appear before the court, are read the complaint, information, or indictment, and if they have not received a copy, they are given one, and that's where the defendant will enter a plea. Defendants have several alternatives when they appear for the formal arraignment. Standing mute, that is refusing to answer, is entered by the judge as a not guilty plea. Another phrase that you'll hear called nolo contender or contendere means no contest. By entering a plea of nolo, defendants in effect throw themselves on the court's mercy. A guilty plea means the accused admits to the charge or a lesser charge agreed to in a plea bargaining agreement, and not guilty, of course, means that the accused basically denies the charge. Keep in mind, though, here also, if a defendant pleads guilty or nolo, as we talked about a second ago, a sentencing time is usually set. Now, usually they don't do it like right away, like in the movies, where you might see I plead guilty, okay, we're going to sentence you. So normally there is a separate hearing that takes place called a sentencing hearing. And last on the list is the omnibus hearing. An omnibus hearing is a pretrial hearing that typically occurs immediately after a person's arraignment. The purpose of this hearing is to determine if the evidence in the case is admissible in court. This includes testimony, which may require that police officers involved in the incident be present. Both the prosecutor and the defense attorney attend this hearing to discuss the pretrial matters regarding the case. Now, there are some alternatives to trial, and some people aren't quite in agreement with this, but there are alternatives to trial. So before cases go to court, defense attorneys may explore the possibility of diverting the case from the criminal justice system or seeking what they call a plea bargain. Diversion is a discretionary decision that can occur at many points as the case progresses through the criminal justice process. For example, a police officer diverts when he or she assumes custody of an intoxicated person and releases that person to the custody of a family member or detox facility. Likewise, a prosecutor who delays prosecution while a defendant participates in, let's say, a psych treatment program diverts. In both cases, a discretionary decision is made that there is a more appropriate way to deal with the defendant other than to prosecute. Diversion provides the justice system decision makers some expanded options with which to respond to criminal behavior. So, by definition, diversion, bypassing the criminal justice system by assigning an offender to a social agency or other institution rather than trying that person in court. Now, plea bargaining is a little bit different. Okay, plea bargaining is the legal negotiation between the prosecutor and the defense lawyer or the defendant to reach an agreement or compromise that avoids a court trial altogether, conserving time and expense. And I know that's irritating to some people. Most studies on plea bargaining have one common thread. The percentage of defendants pleading guilty in federal and state criminal court cases has remained very, very high. Actually, nearly 95% by some estimates are disposed through plea bargaining, not a court trial. So you can see there is some benefit to plea bargaining, but there's also a little bit of a downside to plea bargaining as well. So the trial, and we're getting a little bit closer to time here. The climax of the criminal justice procedure, where we're going to have the trial, and the trial is kind of the end of it all. A bench trial is when a defendant chooses to waive a jury trial and appear only before a judge. So that's a bench trial. The key figures in a trial are the judge, members of the jury, defendant, defense attorneys, prosecuting attorneys, police officers, and witnesses. The judge has charge of the trial and decides all matters with respect to the law. He or she ensures that all rules of trial procedure are followed. Now, if a defendant again waives the jury trial, they can have a bench trial. The jury, the people selected by law and sworn to examine the facts and determine the truth, they decide all matters of fact. So the judge, remember, decides matters of law, The jury decides matters of fact. The trial begins with jury selection before a jury can be assembled. The geographic location of the trial, called the venue, has to be determined. Now, jury selection, they go through a whole process in order to be selected as a jury. There are safeguards built into the selection process that protect the defendant's rights and ensure the public that justice is being done. The judge also has the opportunity to question prospective jurors, although the prosecutor and the defense attorney will do that. The random selection of potential jurors and the careful questioning of each is called voir dire. And that helps to ensure the selection of 6 or 12 fair and impartial jurors. So, testimony. After the jury is selected and instructed by the judge, opening statements are presented. The prosecutor informs the jury of the state's case and how he or she intends to prove the charges. The defense attorney makes an opening statement in support of the accused, or he or she may waive that opening statement. The prosecution then presents its evidence and witnesses' testimony, attempting to prove a crime has been committed and that the defendant actually did it. Through cross-examination, the defense attorney tries to basically discredit discredit prosecution witnesses, the evidence, and the testimony of the police officers. Okay, so that's the testimony portion. So, closing statements and jury deliberation. After all testimony has been given, the jury hears the closing statements, basically a contest in persuasion, first by the prosecution stating that the jury should render a guilty verdict, then by the defense attorney concluding that the defendant is surely innocent, or at least not proven guilty beyond a reasonable doubt. After those closing statements, the judge reads the instructions to the jury. This includes an explanation of the crime, the elements that constitute the crime, alternate charges that could be looked at, and the concepts and presumptions of innocence and reasonable doubt. The jurors then retire behind closed doors to deliberate their findings. They can return one of 3 findings when it's all said and done: guilty, not guilty, or no verdict. And no verdict simply means that there's no agreement that can be reached. That's typically referred to as a hung jury. So now a lot of people say, well, can you try him again? Well, if he's found guilty, you don't try him again. If he's found not guilty, okay, you can't try him again. However, if it's a hung jury, okay, that can result in a retrial. Okay, does that make sense? And that's at the prosecutor's discretion. After that, after the jury deliberation, they come back with the verdict. There is the sentencing. Sentences for people convicted of crimes vary considerably, from lenient to extremely severe. Penalties from probation to many years in prison or even death, depending upon the type of crime. There are sentencing guidelines that I'm not going to go over, but the federal sentencing guidelines set out a uniform sentencing policy for defendants convicted of felonies and serious misdemeanors in the federal system. So in your book, and now on this slide, page 538, looks a little bit about the sentencing continuum, to where you can see all the way less restrictive being probation, all the way up to extremely restrictive, which could be the penalty of death, depending upon what happens. And then finally, case review and appeal. So to ensure that justice is served, the court system provides for judicial review of cases and for a person convicted to appeal the conviction in most instances. So there is the opportunity for that. So what about the police officer? And then we're going to have to finish up because we're running out of time. So the important part is preparation. Preparing a case for court. So preparing a case for prosecution. Preparation. plays the biggest part in an officer's success on the witness stand. The more prepared you are, the more confident you will appear, and the more confident you will be in front of the jury, and less likely they will fall victim to the many ploys that the defense is going to use. And the defense is going to use a lot. The prosecution must prove, remember, their case to what level? Beyond a reasonable doubt, the degree of proof necessary to obtain a conviction. To assist in this, the officer should review and evaluate all evidence, positive and negative, chain of custody, review all the reports on the case, review any documents that may be requested by the defense attorney so you know exactly what might be asked of you, review training that may be called into question by the defense, prepare your witnesses, and hold possibly a pretrial conference with the prosecutor and have the prosecutor tell you, kind of walk you through what they may ask, what expectations they're going to have as far as the case, because we know the defense is going to be looking at that. So appearing as a witness, most police departments have regulations regarding attire. When an officer appears in court, some departments specify you should appear in uniform. Others say that a suit and tie is fine. But just remember, can a jury think you are less credible based on the way you act or dress on the witness stand? The answer is yes, because they're going to determine your level of credibility as a witness, sometimes based on your appearance, sometimes based on what you say, sometimes based on how you act on the witness stand. So also keep in mind that officers should not discuss the case while waiting in the hallway to testify, or joke around with a defense attorney or with anybody else in there, because you never know, there could be a juror out in the hallway that might overhear a statement that's made by an officer, which could create a grounds for a mistrial. So again, your credibility here is at stake. Testifying under direct examination, that will be where it's critical. And when your name is called, you're going to have to answer up here, present, or whatever. You're going to move directly to the front of the courtroom with all of those people looking at you. You're going to go behind the attorneys, and you're going to go over to where the witness stand is, and you're going to be sworn in as a witness on this case. And the officer should be, professional, speak clearly and firmly with expression, answer with confidence and certainty, answer questions directly. Don't volunteer information. Pause before you answer. Think about the question. Refer to your notes if you don't recall exact details. Nobody's perfect. Admit calmly when you don't know an answer. You don't have to know all the answers. Admit quickly any mistakes that you might make testifying in court, and then avoid police jargon and sarcasm and humor. Now, under cross-examination, you need to understand that the defense's job is to cross-examine you, and they're going to attack the prosecution's case. And one way they're going to do that is attack you. Not physically, but some of the ways that they're going to attack you would be through discrediting your testimony. So during cross-examination, the defense attorney may be friendly or rude, and they're there to attack the credibility of your testimony and maybe your knowledge to discredit you, maybe your investigative skill. They're going to be trying to force contradictions or inconsistency in your testimony, or ask leading questions to maybe get you to misquote something, or ask us for a simple answer to a very complex question. So these are all things that they're going to do. But again, your job is to remain as professional as possible, because that's going to make you look even more credible as you start to answer questions. And think about this. An example of a defense team able to discredit a police officer was really seen in the O.J. Simpson trial when the defense attorneys were able to challenge the testimony given by former LAPD detective Mark Furman, causing him basically to assert his Fifth Amendment rights against self-incrimination. So you can see, how bad things can get. Now, on both sides can call expert testimony if there's a scientific, technical, or other specialized question that needs to be asked. So there are expert testimonies, and then of course after testifying, officers should not leave the stand until you're instructed to do so, and you should wait in the courtroom until you are given further instruction. So remember, your credibility is truly at stake. Courtroom security, real quick, is really on the rise, resulting from several high-profile incidents. A lot of times they'll have licensed deputies that serve kind of as security in there, and that's kind of enough said on that. We're not going to go through a lot of these different things that talk about courtroom security. So in summary, because we're coming up on time, and we're actually doing pretty well on time, our judicial system operates at both the state and federal levels. The federal court system has 3 tiers: district court, appellate court, and the U.S. Supreme Court. Our criminal justice system is based on the adversary system. And the most important rule for testifying in court is, of course, always tell the truth, because you don't want to get caught telling anything less. So with that being said, that will be the end of this chapter. And until our next lecture time, that will be it. If you have any questions, go ahead and post them on the general discussion board, and I will answer them as quickly as possible. So until then, I'll talk to you next week.